Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today may be the day I earn your subscription. For today's case, we're dealing with right to try medication. This is the ability of a person to use a medication that may not be FDA approved, but they want to use it anyway. Now, the case we're going to cover is from 1979. This has been modified and superseded, at least in part, by legislation from Congress in 2018. So in 2018, Donald Trump signed into law a provision that would allow people the right to try. So this Supreme Court case precedes that law. But we're going to review the case anyway because it has something to teach us about the laws that existed at the time and also the fact that, Congress can modify the law when they actually get their act together. When the Supreme Court is interpreting a statute, you know what Congress can do? Change the statute. Whoa, they did that in 2018. Amazing. But let's talk about what happened before that happened. Let's get started with this. The question presented in this case is whether the federal Food, Drug, and Cosmetics Act precludes terminally ill cancer patients from obtaining Laetrile, a drug that was not recognized as safe as effective within the meaning of the relevant law. The relevant law, as amended, prohibits interstate distribution of any new drug unless the Secretary of Health, Education, and Welfare approves an application supported by substantial evidence of the drug's safety and effectiveness. The term new drug includes any drug not generally recognized among experts, qualified by scientific training and experience, to evaluate the safety and effectiveness of drugs, as safe and effective for the use of conditions prescribed, recommended, or suggested in labeling. In 1975, terminally ill cancer patients and their spouses brought this action to enjoin the government from interfering with the shipment of the drug Laetrile, which was a drug that was not approved for under the Act. This is a whole controversial thing, dealing with this cancer medication in the 1970s. Didn't really pan out, but, still people wanted to try it. Finding that Laetrile in proper doses was non-toxic and effective, according to the district court at least, the district court ordered the government to permit limited purchases of the drugs by one of the named patients. Okay, so we've got a couple different things going on. We've got the regulation of medicine by state law, and we've got the regulation of medicine by federal law. And one of the things that the federal law can deal with is interstate transmission of drugs or medications. So the idea is you can't transmit it between states. The individual states can practice medicine. And then the federal government comes in and tries to prevent interstate commerce related to that medicine, and that becomes a whole fight. But that's where the FDA is coming in. It's like, unless this drug has been proven safe and effective, you can't transmit it between states. I suppose if you can grow your own within your own state, well, maybe it's a different fight, but these people wanted to import it. So there was that. So the FDA say no. And the district court said, well, it's non-toxic, it might be useful, so what the hell? So that's where we're sitting in 1975. After a completion of administrative hearings, the commissioner of the FDA issued an opinion in 1977. Having determined that Laetrile was a new drug within the meaning of the law, the commissioner proceeded to consider whether it was exempt from pre-marketing approval under the 1938 or 1962 grandfather provisions. So there are certain provisions dealing with drugs that existed in the before time. For example, like aspirin and Tylenol. I once heard it said, and I don't know how true it is, but I once heard it said that if Tylenol had to go through modern procedures, it would have never gone approved. But of course, it existed and was approved in long ago. Well, approved, we're using the term very loosely. It existed for sale. Yeah. So older drugs are exempt from this stuff because they're just on the market forever. So what the hell? One of the facts presented, the commissioner found that Laetrile was not qualified under either clause. So this is not an old medication that existed before. This is new in the FDA commissioner's view. There's no showing that the drug currently known as Laetrile was identical in composition or labeling to any drug distributed in the before time. Nor could the commissioner conclude from evidence submitted that, as of 1962, Laetrile in its present chemical composition was commercially sold in the United States, was generally recognized as safe, and was labeled for same recommended uses as currently marketing. So this is not an old drug after the FDA does its review. In the FDA's opinion, this is a new drug. Didn't exist in the before time. So it is new within the FDA's conception. Fair enough, I suppose. The Court of Appeals addressed neither the statutory nor constitutional rulings of the district court. Rather, the 10th Circuit held that the safety and effectiveness terms used in the statute have no reasonable application to terminal ill cancer patients. So this is an interesting idea from the Court of Appeals reviewing this. The FDA deals with the safety and efficacy of drugs. So the district court said, okay, these are kind of non-toxic and they might be okay. So the district court tried to say they're safe and effective in so many words. The Court of Appeals actually kind of goes a step further and says safe and effective is irrelevant. Safe and effective is irrelevant when it comes to these patients, these cancer patients. Basically, they're going to die anyway. So safe and effective are not really concepts that exist in this domain. That's the Court of Appeals view. That's an interesting way to go, I suppose. However, presumably because the commissioner had found some evidence that it was toxic when orally administered, they ordered that it only be done intravenously. Sure. In addition, the court directed the FDA to promulgate regulations as if the drug had been found safe and effective for terminally ill patients. So yeah, it's like, we're going to tell you it's safe and effective by law. And we want you to publish regulations saying it's safe and effective, by which we mean we don't care if it's safe or effective. This is an interesting interpretation from the Court of Appeals. So you can probably tell right away, without reading one more word of this, how this is going to go. The FDA has the authority to determine if drugs are safe and effective. The Court of Appeals has just told them, ignore the safe and effective part. You can probably tell this is how this is going to go from the Supreme Court right away. But let's read more anyway. The Federal Food, Drug, and Cosmetic Act makes, or at least made at the time, because again, superseded by law in at least 2018, made no special provision for drugs used to treat terminally ill patients. By its terms, the Act's pre-marketing approval for any new drug, unless intended solely for investigative use, or is otherwise exempt from one of the grandfather drugs. So if it's experimental in a proper experimental sense, like it's being gone through clinical trials, right, that would be a different exemption. It doesn't have to be safe and effective to go through clinical trials. That is under its own regime. When constituting a statute so explicit in scope, because this one says safe and effective in pretty explicit words, the court must act within certain defined constraints. If legislative purpose is explained in plain and unambiguous language, the duty of the court is to give effect to the terms. This is pretty standard for law. If the text says stuff, then you can kind of stop reading. It just says it. And those words mean things. We've talked about this lots. We talked about this with respect, for example, with the CDC's apparent godlike authority to issue all the rules ever. And we're like, yeah, you can only do that by ignoring a whole bunch of other words. The words in the statute mean things. You're ignoring a whole bunch of other words, courts. The Supreme Court agreed. And here the Supreme Court's like, yeah, the statute says safe and effective. A Court of Appeals, you can't say safe and effective is irrelevant. It's right there in the text. If it needs to be changed, it needs to be changed by Congress. And incidentally, you need to wait another 50 years for that to happen, but you'll get there eventually, right? Nothing in the Act, when it was first established for review of drug safety, which added in the current standards, suggests Congress intended the protections only for persons suffering from curable diseases. To the contrary, in deliberations preceding the Act, Congress expressed concern with individuals that fatal illnesses, such as cancer, should be shielded from fraudulent cures. So the Supreme Court reads the law, which doesn't say anything about people with incurable cases, and also notes the history of the Act, such as it might be informative, would directly go the other way. Congress was and probably should be concerned with the snake oil, especially to particularly vulnerable patients. So it is not particularly surprising that Congress didn't give a carve out for it in 1977. That was a huge concern of theirs. So, fair. That's what Congress said anyway, and the Supreme Court's here to do what Congress wants, especially when it's statutory, right? This isn't a constitutional question. This is a statutory question. We're not raising constitutional questions. We're just saying, Congress wrote a law, what does it mean? Well, I can read the words on the page. The relevant reports from Congress, the House reports, for example, and the Senate report, note with approval the FDA's policy of concern effectiveness when passing on safety of drugs prescribed for life-threatening diseases. The Congress is concerned. In establishing the statutory scheme, the FDA has never made an exception for drugs used by the terminally ill. As the court has recognized, the construction of statute by those charged with the administration is entitled to substantial deference. See, for example, Chevron. Although, thank God, on this particular one, I don't really have to lean on Chevron too hard because I've got the statutory text. So I don't actually have to go to Chevron, which makes me much happier. So, yay. In the Court of Appeals' view, an implied exemption from the Act was justified because safe and effective standards set forth could have no reasonable application to terminally ill patients. I don't know. I'm sorry, but no. The Congress and the FDA have an interest in what the terminally ill is taking, not for least reasons that it could kill you faster. And we do have a concern about preservation of life and life being precious in some respects. So you might die in 3 months, but it's 3 months. If it kills you now, that's not necessarily good. And we're concerned about you taking the snake oil because it says cure that cancer right up. We're concerned about people buying these products to people who are particularly vulnerable, particularly desperate. These are kind of reasonable concerns. There's kind of a reasonable connection there, perhaps even more so depending on your point of view. I mean, what would a terminally ill person pay in order to not die? There's definitely some factors there that need to be taken into consideration. Under our constitutional framework, federal courts do not sit as councils of revision, empowered to rewrite legislation in accord with their own concepts of public policy. And right about now, you might be thinking to yourself, Obamacare and Justice Roberts, but let's press on. Only when a literal construction of statute yields results so manifestly unreasonable they could not be fairly attributed to congressional design will an exception to statutory language be judicially implied. Yeah, if it makes no sense, then we'll try to avoid that reading. But it makes sense, so we're not here to just revise it. We're here to do what Congress wants, if at all possible. A drug is effective within the meaning of the law if there's generally recognition among experts that the drug in fact produces results claimed for under the prescribed conditions. The concept of safety is not without meaning to terminal ill patients. Few, if any, drugs are completely safe in the sense they may be taken by all persons in all circumstances while at risk. The Commissioner generally considers a drug safe within expected therapeutic gains, justifies the risk entailed, a cost-benefit analysis. For the terminally ill, as much as anyone else, a drug is unsafe if its potential for inflicting death or physical injury is not offset by the benefit. More too, there's a special sense in which relationship between drug effectiveness and safety has a meaning in the context of the incurable illness. And otherwise, harmless drugs can be dangerous to any patient if it does not produce its purported therapeutic effects. So, yeah, if it doesn't do what it says it's going to do, then it's all downside, right? If you're thinking about effects versus side effects, if you're thinking about effects versus side effects, if it doesn't do what it's supposed to do, there are no effects. Everything is side effect. It's all downhill. So there is a meaning there within the meaning, and perhaps more so for the terminally ill. The FDA's practice also reflects the recognition amply supported by medical testimony that diseases such as cancer, it's impossible to identify a patient as terminally ill except in retrospect. We can only give odds. We don't know for sure. Cancers vary considerably, and responsiveness in their forms of therapy. Even critically ill individuals can have unexpected remissions and may respond to conventional treatment. Yeah, stranger things have been known to happen. Is occasionally occurred where a person, on death's door has, for no particular reason that medical science can figure out, just started to get better and got cured. The body is weird sometimes. We are not yet masters of all the things medicine. So yeah, even for a patient knocking on death's door, there are downsides because they, maybe it will rob them of the chance of whatever small chance of probability there is. There's something there. Thus, as the Commissioner concluded, to exempt from the Act drugs with no proven effectiveness in the treatment of cancer would lead to needless deaths and suffering among patients characterized as terminal who could potentially be helped by legitimate therapy. At least, yeah, that's arguable. It bears emphasis, although the Court of Appeals ruling was limited to Laetrile, its reasoning cannot be confined, which is always a good thing for courts to think about, right? When you're thinking about a rule as a court, right? When you're thinking about the rule, you have to think a little bit beyond the immediate context, especially as you're a Court of Appeals, especially if you're the Supreme Court, right? The rule you create will not serve merely this cause. It's now a rule that exists. And if you create the rule, you have to spend a little time thinking about how it would apply in other contexts. Yeah. To accept the proposition that safety and effectiveness have no relevance for terminal ill patients is to defy the authority over all drugs, however toxic or ineffectual for such drugs. Right. I mean, if that's the premise, right? If the premise is safety and effectiveness are irrelevant, then it must necessarily be true that toxicness is irrelevant, ineffectualness is irrelevant, which means literal poison is irrelevant, because we're not allowed to consider those factors. That's a logical conclusion. If history is any guide, this new market that would be created would not be long overlooked. True that. Since the turn of the century, resourceful entrepreneurs have advertised a wide variety of products for simple and painless cures for cancer, including lilaments of turpentine, mustard, oil, eggs, and ammonia, peat moss, arrangements of colored floor lamps, the light colors will make it better, paste from glycerin and Limburger cheese, mineral tablets, and fountain of youth mixtures of spice, oils, and soot. In citing these examples, we of course do not intend to deprecate the sincerity of Laetrile's current proponents or imply any opinion about whether that drug may ultimately prove safe and effective for cancer. But historical experience does suggest why Congress could have reasonably determined to protect the terminally ill no less than other patients from the vast range of self-styled panaceas that inventive minds and, con men with the step right up, give it a chance, can devise. There's a lot there for Congress to be concerned about and the FDA to be concerned about. That's a legitimate consideration. Thus, that brings us to the end of the case of United States versus Rutherford. Again, this is from 1979 and has been superseded by statute, at least in part, from 2018. But at the time, the dominant consideration was the safety and effectiveness of drugs, which is probably a very good thing, particularly if you know literally anything at all about the snake oil of the early 20th century. It's depressing. And people selling all kinds of miracle cures, and it's the con men. It's pretty depressing. So yeah, there's probably need to regulate in that space. So Congress said, how about only safe and effective drugs? Logical. And some people said, well, we want to try this drug and the FDA won't let us. And the law at the time, that's what it said. And then, the Supreme Court basically says in so many words, okay, well, that's a statutory consideration. And of course, when the Supreme Court is interpreting statute, Congress can overrule them. And did overrule them, at least in part. And now a different balance has been struck. That's kind of how it's supposed to work in our three branches of government. Government worked, I guess. And that brings us to the end of the consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.